It was extremely interesting. We had very few prominent people, especially we had with us Luigi Ferraioli. I don't know whether you have read Luigi Ferraioli's books or articles. He's one of the leading legal philosophers in Italy in general, and especially on criminal law. So he was a judge.
Wow.
He has a theory of criminal law. He has written several books on criminal law. So it would be very, very interesting a dialogue between you and Luigi. Luigi is is not also the youngest, but nevertheless is very active and also a passionate scholar. He believes that legal theory is a kind of civic commitment. So this is the way also I conceive legal theory.
Yeah, I agree.
So it would have been very interesting. We had also Mota Kremnitzer, is an Israeli.
I know him. Yes, he's interesting.
A very interesting guy, criminal lawyer. And also we had Joseph Margulis. Margulis, I don't know whether you know him. He is still the counsel, the lawyer of a few people still in Guantanamo. So he has been is the lawyer of a few Guantanamo people, actually, of one guy called Zubadaya. And he told me that this guy has been tortured in, I don't remember which year, I suppose 2003, 2004, I don't know. 200 times in 1 month.
Wow. Yeah.
By waterboarding. So he was submitted to waterboarding 200 times. Anyway,
yes.
It's a great pleasure to have you. I don't believe you need any introduction, but I would say that Anthony Duff is, may I say that you are possibly the leading philosopher in criminal law in the Anglo-American world. You are a leading figure. You have written a lot and extremely interesting books. I don't want to mention them. The list is too long. So I think the best thing I can do is to give you the floor. Thank you very much, Anthony, to be with us.
Right, thanks very much. It's nice to be here, even if only virtually. And I'm sorry I missed the conference you had, but it sounded fascinating. I couldn't make it. However, it's nice to be here today. I've got a PowerPoint, which I'll try to present to make it easier to see where I'm going and what I'm saying. Let me try this. Yes, that seems to work. Can you see that?
Yes.
Yes, good. Okay.
Thank you.
So, avoiding cruelty. There are clearly many dimensions to the return of cruelty in criminal law, and some you've discussed in your conference, many you've discussed. But I want to focus today on just one dimension of cruelty: the failure to recognize offenders as our fellows. It's often tempting, and this figures in both policy and rhetoric, to see those who commit crimes as not as our fellows, but as other. More precisely, those who commit serious crimes of the kind that we, the good guys, don't commit. So, we'll commit, they might say, some kinds of crime, tax evasion, driving offences. But the others are those who commit crimes that we don't commit, the we being the law-abiding group. We might see them as enemies, against whom we, the law-abiding, must protect ourselves. Jako's notion of enemy criminal law, Feindstraffrecht, and you extend that to cover not just a small group of offenders, as he does, but cover all serious offenders. They're the enemy. Or we might see them as evildoers, as the evil ones on whom we, the good guys, must inflict the suffering they deserve as retribution. That's a kind of common retributive trope. Or we might see them in more pragmatic terms as dangerous beings whom we must somehow deter or incapacitate to protect ourselves against them, rather than seeing them as rational, responsible agents with whom we need to engage. Strawson thought famously about the objective attitude towards others. We see them not as agents or as fellows, but as objects to be manipulated, controlled, made safe. And this kind of perspective, where the offender is the other, the outsider, the enemy, it enables and encourages cruel kinds of treatment. It's easier to mistreat someone if you see them as other, not as a fellow. It's also itself a kind of cruelty. It's a kind of denial of fellowship, which is, in a way, the most cruel thing you can do to a person. You deny that they are your fellow. And it's worth noting that this kind of perspective on offenders as the other can be encouraged or made easier by the natural way we talk about punishment. We talk about what we should do to them. And that's the natural way to talk, rather than talking about what they should do to us if we put ourselves in offender's shoe, or what we should do to some of us, to those of us who commit offences. So it's hard to avoid the us and them dichotomy, which portrays the offender always as the them, the other. Once we recognise the pervasive nature of this kind of cruelty, this denial of fellowship, one response is abolitionist. We argue, as we argued in the past, we should abolish capital punishment because that is itself inherently, inevitably cruel. And that argument has been won at least in Western Europe, not everywhere. Going further, people say we should abolish prisons because prisons are inherently, inevitably, unavoidably cruel. So abolish prisons. Or abolish punishment as such, because punishment as inflicting suffering is inherently, unavoidably cruel. Or abolish the police, as the so-called defund the police movement in the States, because the police are seen as an organ of the state which is inevitably oppressive and cruel. Or abolish criminal law itself. This is the most radical kind of abolitionism, because any criminal law seeks to impose a set of values or demands on an oppressed majority, and we can do without it. Now, of course, one question of abolitionists is just what are they abolishing? If they say abolish the police, what do they mean? And also, crucially, what do we replace this by? If not the police, then what do we do? If not criminal law, then what? But I want to look at a different route and ask whether we can avoid going down the abolitionist route. Can we imagine a system of criminal law which is not cruel? A system which we could aspire as an ideal which is worth living by. Of course, it won't include capital punishment. I take for granted we can abolish that and have abolished that properly. But the question is, can it include non-cruel versions of prisons, of punishment, of the police, and of criminal law itself? That's my question today. Can we avoid being driven down the abolitionist route while still avoiding cruelty? So to see what's possible, we need to start with political theory. We need to ask what role criminal law could play in a decent political community, in, I would suppose, a democratic republic of citizens. And I was struck by this phrase in the Italian constitution: citizens who have equal social dignity and equality before the law. And that's a very telling phrase, equal social dignity, as capturing something important about the notion of a democratic republic where all citizens, emphasize the all, are recognized as having equal social dignity. The various slogans we can appeal to here, we could talk of, as talking talks, of equal concern and respect. The state owes us, all of us again, equal concern and respect, and we owe each other that kind of concern and respect as our fellows. We look at Pettit, wonderful, what he calls the eyeball test. Citizens can look each other in the eye as equals, without fear, without subordination or domination. We're able and willing to look each other in the eye as our fellows. In such a polity, we see ourselves as engaged together in an enterprise, a civic enterprise of living together. The notion of community and solidarity are clearly important here. And that enterprise of living together is based on a set of values which structure our, we might say, our civil order, the structure of our social life. It structures our common good as the aims, the values which we are together pursuing and living by. We often find a sketch of this in the early parts of a constitution, as e.g. in the first few articles of the Italian constitution. They define the civic enterprise, they define the civil order as those values which define our collective civic political life. And again, the important point to emphasize is that if you read the Constitution, if you read Dworkin or Pettit, these values bind all citizens to recognize each other as fellows. It doesn't say if you obey the law, you have dignity. If you obey the law, you are owed concern and respect. It doesn't, you are a citizen and therefore owed, as such, equal concern, respect, and dignity. So all citizens are included in the polity. I should note in passing, of course, if we look at criminal law, many of those who appear in our criminal courts and get punished are not citizens. They're visitors, they're refugees, they're temporary residents who are here as tourists or to work. So we need to ask what we can say about them. I can't pursue that here. I'd say that they have the distinctive normative status of being a guest, and guests bring with it, that status brings with it, distinctive rights and obligations. But we focus primarily on citizens because it's our criminal law. So that's a very, very gestural sketch. So we think then of this kind of democratic, inclusive, respectful polity. Why would we need a criminal law at all? Well, first of all, if we take our values seriously, those values that define us as a polity, we must take seriously breaches of those values. Attacks on citizens' rights, attacks on our common goods. We must recognize those as serious matters which we can't ignore. That's what it is to take our values seriously. That, of course, involves trying to prevent such violations of our values. We find ways to prevent them which are consistent with the respect due to each other, with our dignity. But still, we must recognize that since we are human, violations will occur. People will flout the law, people will attack each other, people will attack our common goods. We're all prone to this. We're all human, we're all fallible. So we need to ask, how do we respond to violations when they occur? Now, again, a natural tempting response is often exclusionary. We see the offender, the person who violated our values, as someone who's violated the social contract, who's violated the bonds of community, and therefore has excluded themselves from citizenship. And one common kind of punishment is of that kind. The offender has excluded themselves, and thus we can exclude them by breaking out the bonds that tie us together. That's a common response, and the rhetoric of punishment and its practice often embodies that kind of response. The offender, the serious offender, is now other because they've made themselves other by offending. And that's, of course, the path to cruelty. The offender is now the dangerous or hostile enemy, the other. The question is, can we envisage an inclusionary response which will treat offenders, those who have broken the law or committed serious crimes, treats us still as our fellows, which still preserves our equal social dignity, our meaning all of us, offenders, non-offenders alike? Can we have an inclusionary response which does not go down the path of cruelty and exclusion? Surprisingly, my answer is yes, we can. At least we can imagine this as an ideal to strive towards. And criminal law could ideally, I emphasize the ideally. We're talking here not about the criminal law we have, but the criminal law we could aspire to have as an ideal. And that could be part of an inclusionary response. Because criminal law could be seen as sustaining our civil order, sustaining our collective way of life by recognizing and responding to the wrongs that violate our shared values. That's the function of criminal law, is to identify and respond to wrongs that violate our civil order by violating the values that define it. And there are three dimensions to criminal law understood in this way. First, you've got the substantive criminal law, the so-called special part which defines offences. It defines murder and theft and rape and so on as crimes. In doing that, it's defining a set of public wrongs. In other words, wrongs that concern us all as citizens, wrongs that impinge on our shared values and therefore require public response. To define a kind of conduct as a crime is to say that is our concern. It's not like a private matter between those involved. It's a concern all of us because it violates the values we live by. Second, the criminal process, in particular the criminal trial, constitutes that formal public response to public wrongs. It calls to account those who commit or are accused of committing those wrongs. And I'll come back to the criminal trial shortly. But that's the second dimension of criminal law. We've got the criminal law which defines wrongs, the criminal process as our response to those wrongs, and then criminal punishment, which I'll come back to later on, as somehow reinforcing that response to the wrongs. The question then is, if that's what criminal law is, defining wrongs, criminal process and punishment, can that constitute an inclusionary response which respects dignity, which is not cruel, which is humane rather than cruel? I've got the same question about policing as well. I can't deal with policing here. That's a further debate to have. So, how can the criminal law be inclusionary rather than exclusionary? How can it respect dignity? Let's start with the criminal process. I think it's an important but often neglected aspect of criminal law, and especially the criminal trial, which is the culmination of the process. I should note what I say here is set, because that's where I come from, in terms of an adversarial system of criminal trials. A prosecution and defense and adversaries, and the judge is the umpire. But I hope it can also apply with some minor changes to more inquisitorial systems like yours, but you'll tell me if it can't. Now, it's tempting to take a simple instrumental view of the criminal trial. The point is to identify those who committed crimes who are therefore to be punished. The trial aims at identifying the guilty as a prelude to punishing them. From that point of view, it could be useful to have the accused person take part, give evidence in the trial. It might help the trial, the court, find the truth. But it isn't essential. We might be able to find the truth without the participation of the accused. So it's useful, but not necessary. What's wrong with this view, I think, is it doesn't do justice to the importance that the accused take part in the trial. For instance, in most legal systems, certainly in ours, I think also in Italy, if someone is seriously mentally disordered, so they can't understand the trial or take any part in it, then they can't be tried. The trial is barred by their incapacity. That's a pervasive feature of criminal trials, that they can't go ahead if the accused person can't take part, can't understand it. Why is that? I mean, it might be you can still find the truth without them taking part. There might be enough evidence of their guilt without them having any part in it at all. But so it seems to me somehow deeply wrong to try a person and then to convict them if they're so disordered they can't understand what the process of taking a part in it. And the instrumental view can't capture that thought. So here's a different view. The trial we can see as a process according to account or according to answer. A person is accused of committing a crime, formally accused. He is called to court to answer to that charge. In an English court, he's there in the court, and the court addresses him, saying, "How do you are you accused of theft with these details? How do you plead?" And the accused answers guilty or not guilty. He answers to the charge. Then the prosecution make their case. Maybe it proves or the accused admits that he committed the offence. I admit that I stole your property, I admit that I damaged your property, and then I must now answer for that commission. I now show I committed the offence, and I'm now held responsible for it, and I must answer to the court for that commission. Maybe I can just admit my guilt. I've got no defence to offer. So I might have a defence. I might say, look, I admit I damaged your property, but I had to do it. I had a justification or an excuse for doing it, so I should be acquitted. And that's the second stage of the trial. If I can offer a defence which exculpates me, if I can offer a justification or excuse for my conduct, then I'm acquitted. If I can't, if I've got no defence, then I'm convicted. And that conviction condemns my conduct as now a proved criminal wrong and censures or blames me as the agent of that wrong. The trial is a process in which holds me responsible. It calls me to answer to the charge. It calls me to answer for my conduct if I committed the offence. And then calls on me to take responsibility for my conduct, to take responsibility by answering for it, by offering a defence or by admitting my guilt. And that's how the trial is a process, not just of trying to find the truth, but of calling an accused person to answer a charge, answer to the charge and to answer for their conduct if that conduct is proved as criminal. And in the end, the court either says, we acquit you because you've not been proved guilty, or we convict you because we now have proved that you are guilty and thus are deserving of censure. And the court addresses the defendant in these terms. So the trial is an attempt, at least, at a two-way communication between the polity and the accused. An attempt because the accused might refuse to answer, but it's at least an attempt. The polity, we collectively say to the accused, we put the charge to him. Say, here you're charged with this offence, how do you plead? The verdict is then also addressed to him. We say to the defendant, we find you guilty or not guilty. And that's why it matters that he can understand these communications. If he's incapacitated, we can't communicate. We can't try him. But also, we look for a response from the accused person. We don't force him to respond. That used to be done in medieval times, but not now. He's expected, he's called on to respond, to answer the charge, to enter a plea, to answer for his conduct. If convicted, he's called on to accept the verdict and admit his own guilt, to take responsibility for his wrongdoing. So in that sense, it's a two-way communication. We call, we hope that he answers. That's a picture of the criminal trial. Why should a polity respond in this way to criminal conduct? Why is this the right way to respond to public wrongdoing? Well, saying we owe it to the victims of crime, when there are victims, and to our own values, to take the wrongdoing seriously and to respond to it. If we care about the values we're committed to, then we must respond to wrongdoing. And that response should take this form of calling the person to account, because we owe it to the offender to treat him not as an outsider or enemy or dangerous animal, but as a responsible member of the polity who can and should answer for his conduct. So a central feature of being responsible, of being a responsible agent, is I can answer for my own conduct and should be called on to do so when appropriate. So the criminal trial, understood in this way as according to account, does justice to offenders as members of the community. It addresses them as responsible agents who can take part in the process and answer for their actions. It treats them not as objects to be disposed of, but as agents who can, in this way, answer to us for their actions as we answer to each other. It treats them inclusively as members of the community who answer to their fellows. The important point is that if you call someone to account, that is itself to treat them inclusively. You treat them as a fellow who answers to us as we answer to him. And that's an important point about the criminal trial seen in this slide. It is an inclusive process. So if properly conducted, and that's a big if, we need to think how trials actually function. Are they run in such a way that the accused does have the status of a member who is being called to account? Often they don't. In some courts, they're in the dock as the other. I was actually told that one of the best examples of a properly respectful criminal process is the American court-martial, a military court, where the accused appears in uniform and is addressed as a fellow soldier by the court. So you think of ways in which the court can be so structured that the accused is clearly there as a person with equal social dignity before the law. But if it is conducted thus, then it is a respectful process which is inclusive rather than exclusionary and treats them with the dignity they deserve. An important part of this is that the accused is an agent. The accused is there with an active role to play as a citizen called to account by their fellows. This will be important later on. That's the trial. You might be wondering, what about punishment? Because punishment sees the hardest aspect to reconcile with relations of dignity and respect. Punishment as the material burden which follows on conviction, normally follows. Can we also make sense of punishment along these lines? Answer, yes, we can. We can see punishment, I suggest, as itself, like the criminal trial, as a would-be two-way process of communication between polity and defender, which treats the offenders with respect as fellow citizens. So punishment can be seen as continuous with the criminal trial in its aims and its values, or so I argue. Punishment, first of all, communicates to the offender from the polity. If I'm the offender, the polity says to me, here's essentially you deserve what you've done wrong, and we blame you, we condemn you for it. That's essentially to make clear to me the seriousness of our wrongdoing. So punishment in that way is a one-way communication from the polity to the offender. And that's quite a common thought about punishment. It expresses something to the offender. But also, punishment aims to serve as communication from the offender to the polity. The offender pays his debt, as they say. He makes reparation, an apologetic reparation for my crime. And that's the way in which punishment aims to become a two-way process. So, for instance, I'll give a bit more concrete form to that. My sentence might be, I'm sentenced for my crime to undertake so many hours, 100 hours of unpaid community service. I take to work on some community project without pay, and that's my punishment. I do it for 100 hours or however long it takes. In undertaking that community work, I thereby make reparation for my crime. I express to my fellows my recognition that I wronged them, and here's how I want to make up for it. So punishment is undertaken, we hope, as reparation for the crime. In this way, then, by communicating censure and by demanding this kind of apology, we take both the wrong and the offender seriously. And the offender, by making this reparation, can communicate to his fellows his recognition of his wrong and the need to repair his relationship with his fellows. That's the ideal story of punishment as an inclusionary, respectful process of communication. This is important, again, because we owe it to offenders and victims alike to try to bring offenders to recognize the wrongs they have done. That's part of what it is to be a community of responsible citizens. And offenders owe it to their fellows to make reparation, not just to their victims, but also to their fellow citizens whose values they've violated. So that's why both kinds of communication matter. We have to make clear to the offender the wrong they've done, and the offender ought to make clear to us that they recognize that wrong. And seen in this light, punishment can be seen to treat the offender with appropriate respect and in an inclusionary or exclusionary way, because it addresses them as responsible agents who can recognize and repent of their crimes. It calls them to recognize their crime. It addresses them as members of the community who can repair the relationships their crimes damaged. There's still the inclusionary. It says, yes, you've done wrong, but here's how you can restore your relations by undertaking your punishment. And also, crucially, it gives them an active role in punishment. Punishment is to be undertaken as apology, not just undergone or suffered. I think it's important because often we talk of punishment as to be something we impose on offenders, we inflicted on them. They're simply the passive recipients of the punishment. But most punishments, certainly things like community service, probation, and fines, they're required rather than imposed. We say, here's what you must do as your punishment. You must undertake this unpaid work, you must attend these meetings, you must pay this fine. So punishment on this view is active, something the offender has to do. It all treats them as agents. That sounds all well and good, or perhaps not. But what matters in part is now what material forms punishment can take. The court requires the offender to undertake a sentence. Is what's required something they can undertake as reparation, without loss of dignity, without loss of self-respect? What modes of punishment are possible on this view? And we need to look more carefully than theories often look at what's available in the way of modes of punishment and what they mean. And some modes of punishment seem clearly apt for this kind of account. They can be administered in ways that are not cruel, but are inclusive and respectful. I think obvious examples are what we call community service orders. You're ordered to undertake so many hours of unpaid work on some specified community task. Or probation, where you're ordered to be supervised for a certain period. You go to meet your operation officer, you might be ordered to undertake a program to address your offending, that kind of thing. And those seem clearly apt for this kind of punishment. Again, because the offender undertakes the punishment as an agent. Something I must do, not something that's done to me. Punishment can be, if it's not shaming or humiliating, be consistent with my dignity. I can undertake it without losing self-respect. There's some theories that talk to punishment as shaming. They argue that we should impose community service in ways that shame the offender. They're meant to wear uniforms, but that's not the view I have here. The punishment must be administered in such a way that it doesn't shame or humiliate. It's something a person could undertake without loss of dignity. And that can be true of community service. And these are inclusionary. They're ways in which I can restore my relationship with my fellows by paying my fine, by undertaking unpaid work, by addressing my offending through probation, and so on. So in these ways, punishment can be non-oppressive, non-shaming, respectful, and inclusionary. But we now come to imprisonment, which is the obvious problem here. Because surely it might be said, imprisonment can't be understood in these communicative agential terms. Imprisonment is surely imposed on the offender. He's been locked up. He's not an agent. He's just locked up. He's locked up behind walls, behind bars, and thereby excluded from community. So imprisonment on this face looks like it's something which is inherently exclusionary rather than inclusionary, and something which is simply imposed or inflicted rather than undertaken by the offender. So imprisonment seems like it can't fit this picture of punishment as an inclusionary, respectful requirement. So maybe this view of punishment might seem to entail that we should abolish prisons. We can retain criminal law and retain punishment. We didn't go down the abolitionist route in those respects, but maybe we should abolish punishment. Abolish prisons. And we then to ask, okay, what do we do instead? But maybe things aren't quite that drastic yet. There are ways of making prisons less exclusionary and less agency denying. We always look here to the models from Scandinavia, to Norway or Denmark or Iceland, and how they do prisons. And there are important features here which at least might reduce the problem. We can say prison is a kind of temporary seclusion from ordinary civic life. I'm told, look, given what I've done, given the seriousness of my crime, it's going to apply only to serious crimes. I can't carry on living with my fellows in ordinary life. For the time being, I must undertake a temporary seclusion. It matters that it's temporary. I'm secluded not forever, but for a fixed period, after which I will then be back living an ordinary life. So I'm required to seclude myself from ordinary civic life. And that could indeed be a requirement, not an imposition. We could have an open prison. We do have open prisons where there are no bars, there are no walls. People are told, here's where you must stay for this period of months or years. It's true, there's still the background threat. If you leave, then you'll be recaptured. But still, at first, it is a matter of requirement, not imposition. You're required to stay in this place. Or maybe it happens sometimes that you are convicted in court, you're told your sentence is a year in jail, but go home now and come back on the specified date to serve your sentence. Again, it's up to you to report to serve your time. Or maybe imprisonment is now, could be at home rather than in prison. It's a home curfew, you're told not to leave your home for between these hours of this period. So prison imprisonment can be, to some degree at least, something in which I, as the offender, am the agent, not merely the sufferer. Something I'm required to do, not just something I suffer. Within prison, we can find more room for agency. We think of ways of organizing prison life so that there is some degree of self-governance for those serving prison terms. They're not merely subject, excuse me. They're not merely subjected to orders by others, which is the way prisons normally often go. They're allowed to organize their own lives. And again, this is true in some Scandinavian prisons. There's a fair degree of self-governance for prisoners. They're not allowed to leave, of course, but they, within the prison, they can organize their own lives. And again, this gives them agency. And that could include, which doesn't appear on the slide, there are ways of, if I'm imprisoned, I can view it simply as something done to me. I sit in my cell, I suffer my imprisonment, and I'm passive. But I can, in a way, make it my own. I can become an agent. I can recognize it is appropriate. I can then undertake the prison term itself in a way that seeks a constructive way forward. So one can be an agent in prison, even if one can't leave. We can also, of course, make the prison walls themselves more porous. We can preserve connections between the prison and ordinary life. Connections both with one's family and also with the political life, which includes, of course, the right to vote. I'm really not sure now. We can think of these kinds of measures, these ways of making prison less simply a matter of something imposed on us, and more something we're required to undertake as punishment, something within which we can still be agents, and after which we're still to be welcomed back by our fellows. I'll come back to that in a minute. Is this enough to make imprisonment justifiable within this conception of punishment, as opposed to process of two-way communication? Can we say imprisonment need not be cruel, oppressive, exclusionary, agency denying? I'm honestly not sure. I hope it can. Certainly, prison would be justified only for rather few offenders, for a crime so serious that it means we can't live with this person for the time being. The only way to recognize the nature of their crime is a period of seclusion. That's only true in rather few cases. So it certainly won't justify mass imprisonment, and nor should it. My hope is that it can justify a limited use of imprisonment for very serious offenders. But I'm not entirely confident with that. Finally, almost finally, punishment comes to an end. In a civilized system, you serve your prison term and then you are released. What happens then? It's important that you are recognized as being now rehabilitated, reintegrated, formally as a citizen who's paid their debt. Essentially, as things are now, certainly again in Britain, when you finish your prison term, you usually walk out of the prison. There's no formalities, no ceremony, you just leave and find your own way home. Maybe it's important, just because prison is so manifestly exclusionary, to have a formal ceremony of reintegration. People have suggested this. You're welcome back to the community. But also, of course, apart from any symbolic reintegration, as things are now, again, in some societies, certainly in America, certainly in Britain, there's a whole range of so-called collateral consequences. You leave prison and you're now an ex-offender, and you find you're still subject to many kinds of restriction and limitation. You can't get a certain kind of job because you've got a record. In some parts of the state, you can't vote. You might be barred from access to various kinds of public good, like housing or education. So all kinds of further consequences which fall on those who serve prison terms. And these are part of the cruelty of punishment as now suffered. So we need to look carefully at those and see how far we can avoid these kinds of further harm. If we punish someone, we have to make sure that we enable, assist and welcome them back afterwards. We are sure that they're now treated once again by the and by all of us as citizens who once again are in good standing. And that's quite a demanding claim. So, I've almost finished. I've argued we can imagine a system of criminal law which is decent, non-cruel, respectful, which preserves the equal social dignity of all citizens, including those who offend. It treats them all with respect and recognizes their dignity. It's inclusionary, not exclusionary. It treats them as fellows, not as enemies or dangerous others. Now, of course, it might have struck you, should have struck you, that that kind of system, which I've imagined, which I've sketched in very, very sketchy, very broad outline, is quite distant from our own systems. We can't say of our criminal law, well, I speak for England, you can speak for Italy. It's not true that our criminal law treats all citizens with equal respect and dignity. Criminals are in various ways, or suspects and criminals are treated in various ways, oppressively, without respect, without dignity. Our criminal law is in various ways exclusionary, not inclusionary. So in many ways distant from our own system. But what I've offered it not as a description of how things are now, but an ideal to which we can and should aspire. An ideal of criminal law, which also gives us a standard against which to measure our own existing practices. We can see just how radically we fail to achieve the values that should guide us. So the ideal offers us both a target to aspire to and a standard for a critique of our existing systems. What's also true, though, is that we can't work towards the ideal simply by changing our criminal justice system. Well, that's a demanding enough task. Because criminal law of this humane, decent, respectful kind is possible only within a polity which itself is a democratic republic of equal citizens. So before we can make punishment what it should be, before we can make criminal law what it should be, we need to work towards a more fundamental social political change towards a genuine democratic republic in which criminal law of this kind could be possible. That's a major undertaking. The point is that reforming criminal law must be part of a much more deeper, wider political, social reform, but one that we can imagine working towards and imagine in the end, if not achieving, coming close to achieving. That's my hope. We can aspire to a non-cruel criminal law. The end.
Thank you very much, Anthony. If I can make a remark, I somehow, when you spoke, heard blowing the wind of enlightenment. And we need this wind blowing because now we are living in a different, or we seem to live in a different atmosphere. There are other winds blowing. And I only want to mention that in Italy, till now, so in the first 6 months of this year, we had more than 50 suicides in prisons. There have been more than 50 people in prison suiciding. The conditions of our prisons is terrible. And it is terrible also because a lot of petty offenses are considered crimes, and petty offenders went to prisons. So thank you very much. I think Thank you for the wind animating your words, blowing in your words, and I would like to have some discussion. I would open the floor.
Can I say one thing there in response?
Please, please.
I mean, if we look at our existing systems, whether it's Italian or English or Scottish or American, it's easy to despair. We look at our prison conditions and how inhumane they are. We look at who gets imprisoned, how many are imprisoned for petty offences, how many are imprisoned who have mental health problems, and so on. We look at our criminal law itself, what kinds of things are defined as crimes. We look at in these ways, and we look at, I say, the political winds that are blowing, the winds of exclusion and so on. It's easy to despair. And I think the only answer is abolition. Like especially true in the States. You look at the way, all the various police scandals, abolish the police. It's a natural response. Because what we have is so deeply oppressive and cruel that there's no way to reform it. I can understand that. I still think it's worth asking, well, is there a way which could we imagine as a distant ideal, but still an ideal worth imagining? A criminal law which is not in those ways oppressive and cruel, which I agree would be more limited in many ways. You would probably have many fewer offences. Well, you also define some other offences to do with corporate crime, but we certainly make far less use of imprisonment. Whose prisons would be quite different from our prisons. Now we can imagine that, and it's worth having that in our minds as something which is there as a distant ideal. I agree, enlightenment may be, but that's worth clinging to. Sorry, I'll stop.
No, thank you very much. I have been all my life, because my father was a lawyer, and so I brought up among lawyers, and they were mostly criminal lawyers. So the question of criminal law, punishment, and the cruelty of punishment, the cruelty also of trial. There is a cruelty in trial too. It's not only punishment. The trial is somehow a form of punishment. I've been aware of it since I was, 5, 6, and I've tried also my research, my commitment with university, and has been to find a way to combine in somehow law with humanity, and especially criminal law with humanity. It's not easy, and there is a lot of reason for despair, as you say. Thank you. So I would open the floor if there many questions have been raised, also theoretical question, philosophical question, practical question. So there is a lot to discuss. Dr. Volpi, please.
Thank you. Mi sentite? Sì. Thank you, Professor Duff. My question is very short question about the moment after, we can say, the punishment and the trial. So my question is very simple, but is about what's the relationship exists between we can say judicial error, due to various reasons, confusion in the evidence, incorrect rules, judge error, and criminal trial. How does the possibility of dialogue or the communicative dimension can emerge in the face of an error in the evaluation of the facts, and therefore in the incorrect attribution of guilt to defendant? For example, when a subsequent sentence, many years or decades later, establishes that the person was innocent and not guilty. How and in what ways can we establish the communicative dimension here? Maybe it's more factual or existential, you can say, question, but it's also, I think, legally and philosophically interesting. Thank you. Thank you very much.
Thanks very much. That's an important question. There are many ways in which trials can go wrong, and even in a much improved system, they will still go wrong in the ways you mentioned, which end up with the conviction of a person who in fact is innocent. And here's an special cruelty, which we certainly have, that if you're in prison in England, after a certain time, you can apply for parole, for early release on license. And you go before the parole board and say, I'm looking for release. And one question the board asks is, has this person addressed their offending? Having they recognized their guilt and come to terms with it? If they haven't, then they aren't released. There are people in jail, in prison, who keep insisting on their innocence. And apply for parole, they're told, look, you haven't addressed your offending. You still deny your guilt, so you stay in prison. And then some years later, they're found to have been wrongly convicted and released. So that's what I'm saying terrible about an innocent person who is kept in prison because they keep saying they're innocent. So there's something terrible here. I guess one answer is this, which might or might not be adequate. We must recognize in advance that however improved our system, mistakes will get made, innocents will be convicted, either by judicial error or just, it can happen. Even if the trial was properly conducted, still you get the wrong verdict. So I would like to be able to say that the punishments we impose should be of such a kind that we can say to the defendant, look, even if you're innocent, you should undertake a punishment as recognition of the authority of the court and what you owe to your fellows. Now, of course, that will depend on what the punishment is. As in, it's allow the person to undertake the punishment under protest. I'm innocent, but I will undergo this because I recognize. See, if we can say to the innocent defendant, look, you should still respect the system which has tried you. It's still your criminal law. You be treated fairly. There's been no error. You be treated fairly. So now you should accept the verdict. Even though you believe it to be wrong, you must respect it and undertake the punishment. If we can say that, then that's the way forward. But much then depends on what the punishment is. And I must accept 20 years in prison. That's rather hard. And I must accept to undertake this unpaid work. Maybe I can do that. So there's a real issue there. We mustn't forget that any system will convict innocent sometimes by mistake. So we need to make sure that there is room in the system for recognizing and dealing with that problem. Does that help?
Thank you.
Good.
Thank you very much.
Another question? We have different issues here. Andrea Romeo.
Sì, professore, grazie. I have to admit that I agree with your methodological approach. Just a question. Since law is very complicated and to participate to have an active participation in the process require technical legal expertise, do you think that your democratic and sometimes working sounding model, your accounts of criminal trial, require and justify the necessary presence of the lawyer as to make the accused able to really participate to the trial as equal worth fellow?
Thanks. Yes, you're right. If we're going to say, as I say, that the accused should take part in the trial, it then matters that it's possible to take part. So you look at the Convention on Human Rights, Article 6, the right to a fair trial. It lists various rights you have: the right to be informed of the charges, the right to a translator if you need a translator, the right to legal counsel, and so on. All these ways of spelling out what's involved in being able to take part. it also matters how the law itself is formulated. Ideally, the law should be so formulated that it is anyway intelligible to the ordinary citizen. If that's the law that binds me, I must be able to understand it. And the process must be such that I can understand what's going on. I still need a lawyer to advise me, but I shouldn't be a total stranger to what's happening in court. Of course, there are cases to do with very technical financial crimes where the law might be complex. Even though you might hope that those who are accused are themselves going to be experts in the relevant area, they'll be practitioners, so they will understand what's going on. But the main point is you're right, that if the accused is to take part in the trial to answer the charge, then we must enable that. We must ensure they have the rights and support they need to take part. And that would involve supplying serious resources, including a lawyer and information and translation and so on. If that's not available, then the trial can't be a fair one. Again, that seems to me that should be feasible. It will cost money, of course. You need to have, as things are now, we have a radically underfunded legal system where defenders and often prosecutors don't have the resources to do the job properly. So if you talk to public defenders in the States, they meet their client just before the trial, they get the file just before the trial. There's no time to work out what they can do. So that can't count as a fair trial. So we need to make sure that the system is so resourced that accused persons can get the support they need in order to play their part in the trial. That's not impossible.
Thank you. The question is also, I would say that my sentiment is that we should rethink the child. Somehow the child as we have it, or we had it historically, both in the common law tradition and the adversarial tradition and in the civil law countries, the so-called inquisitorial systems. This, as you know, there was in the past. I mean, I remember when I was a student, we had in Italy at least, when we studied procedural law, civil and criminal procedural law. There were lots of theory. There were theories about the process, the trial, and different, also ideologically confronted. A liberal, for instance, versus, let's say, well, authoritarian or communitarian, and so on. I don't see this discussion now in the legal theory. I don't have any, for instance, that we don't have a discussion legal theory in Italy about the process, and I haven't seen any discussion about it either in England or in the United States. The same in Germany. They had a strong tradition of trial theory in the beginning of 20th century, end of 19th century, and so on. But this is gone, and it has been replaced fully by the attention given to legal reasoning and legal interpretation. But legal reasoning cannot replace institutional structure of how a trial is conducted. So in a sense, legal reasoning also depends on how the trial is done and shaped institutionally. But there isn't any discussion about that. And now, when you speak of communicative punishment, I think, and you speak of the child as a communicative experience. And we had, for instance, in the continent, in Germany especially, this idea of legal argumentation as a kind of legal discourse, again, communication, to Alexi, Habermas, and so on. But no attempt has been done to build up a new theory of trial basing on these new perspectives. So I think we should. It's a task for the younger generation, but I think it should be done. I don't know whether you have what you think about the trial as such, which is because the trial as such can be cruel. It's not only the punishment that is cruel. You remember Dickens. You remember. You remember Bleak House. Bleak House is it's a nearly 1,000 pages novel about just one trial, John Dice versus John Dice. And the punishment there and the despair is then it's not the punishment, it's the trial. So
because John Dice was not a criminal trial, was it?
John Dice versus John Dice was not a criminal trial. It was not a criminal trial. It was a trial about heritage. But nevertheless, even the trial, even when it is not leading to punishment, a trial as such might be, or is, I would say, some kind of harm made to citizens.
No, I agree. I think that there has been actually quite a lot of writing about the trial in the last 20 years or so. Discussions about what the aims of the trial are, discussions about how we should structure trials. More work needs to be done to see how trials, what should the aim of the trial be? Is it just about trying to find the truth, or is there more at stake than that? And secondly, going back to a previous question, if we do say the trial is at least in part according to account, then how can we so structure trials that becomes a non-cruel possibility? And now we're looking at partly just at the rules of evidence, the rules of procedure, partly at how the accused person can be supported to enable them to take part in the trial, and also how other witnesses can be supported. Partly basically things like the structure of the courtroom, who sits where. In an English court, an old-fashioned kind, the judge sits up there on the bench, the accused is down there in the dock, and the rest are in the court. That makes clear there's a hierarchy here, and the accused is already marked out as someone dangerous. So you think about the structure, the architecture of the court, the trial process, how far it is intelligible to those involved, in particular the accused. So all these matters need to be seriously thought about. But there's room there, I think, for some hope. So it's also interesting. I think one way to put more pressure on this is to take the jury seriously. If you have a lay jury, then the trial must be something they can understand, because they in the end have to reach the verdict. So the lay jury can be seen as a kind of check on excessive legal professionalism. The trial is not just a discussion between lawyers, discussion now which must involve the jury, and they must understand. There's a further issue which bears on all this as well. Certainly in recent months in Britain, there have been a series of cases of, especially of climate protesters who've blocked roads or damaged property as part of a climate protest. And they've been charged, accused of criminal damage, and appear in court. And they say that we want to argue a defense of necessity. The only way to prevent disaster is to take steps will then actually bring about some genuine change, and that will involve breaking the law. So they want to argue justification for their conduct. And the courts have, sometimes that's succeeded. Sometimes the court, especially a lower court, heard that defense and acquitted them. And juries have the right to acquit, even if the person is clearly guilty in law. The jury gets to acquit on grounds of their own conscience. But sometimes the courts have said, no, you can't make that defense. That's not a legal defense. You aren't allowed to make that in court. We won't hear you. And sometimes, even worse, defendants who want to make the case have tried to argue it and are then put in jail for contempt of court for insisting on arguing what the court says they shouldn't argue. So there is going to be a real issue there, though, about what kinds, if the accused person is called to answer and called to justify or excuse their conduct, what kinds of justification should the court be willing and able to hear? And how far should the law limit what can count as justification? Or how far should the law say, look, okay, whatever you want to say, we'll hear you, and then the jury will decide? So I think it's issue there about what kind of answer the accused person is going to be allowed to give.
Right. Any other question?
Professore Latorre, buongiorno, Rosario Paradiso. Posso procedere ad una domanda, se mi dà facoltà?
Prego, prego, dottor Paradiso, please.
Okay, grazie per la parola. Thank you, Professor Duff, for your wonderful lecture, and I apologize for my camera, but my computer is this. I will proceed to make some short question. First of all, in the case of non-citizen, can we answer to your first question? What about non-citizen? Focusing instead on your conception of active role and embracing, for example, an interactive model of membership in which even non-citizen or denizen in the American language can show respect and engage participation in everyday social life. So can we respond in a positive way to your first question, what about non-citizen? This is the first question. Second question is about life imprisonment. And I want to focus on your concept of normative membership. First, responsible, first, equal concern and respect in Dworkin terms, and then in membership to a normative community. I will focus shortly on Carlos Nino, conception on objection to death punishment, and sustaining that punishment expel forever the citizen from the normative membership, because it denies the possibility to take part in the discussion, in the democratic discussion. Can we extend this kind of objection to life imprisonment? And the third question is about the role of media, focusing, for example, on Habermas' works about the media and the distortion. In your works, in your theory, in your wonderful lecture, I don't see this kind of matter. But, for example, focusing on the moment, on the scope, on your treatment after punishment, so can you think that often in our democracies, the role of media is an obstacle, for example, with the rage, is a tool for the rage that obstacles the reconciliation between offender and victim? Is this a theory that must be explored in order to maximize the possibility of conciliation? Thank you, and thanks again for your lecture.
Right, thanks very much. Okay, taking your questions in turn. As to non-citizens, I agree with you. There are two ways to go. We need to recognize that non-citizens must be treated appropriately with respect. One way to go is the way Lucia Zedner goes, to say, look, we should not talk of citizens at all, talk of denizens, as you put it. All those who are within the territory are to be treated in the same way as denizens of this country. I want to avoid that because I think it's important to talk of citizens as the primary addressees of the law. The law is their law. As members of the polity, they have made the law, and it's their law now to apply. But guests, then those who come in who are not citizens, whether they're refugees or temporary workers or tourists or whatever, I want to say they have the status now of guests. And of course, guests are owed all kinds of duty and have all kinds of duties themselves. And we should enable guests to take part in our shared life. To be a host is to welcome the guest into your civic home, as it were. So I think that non-citizens can and should be enabled, allowed, helped to participate. Of course, the question about how far that should go, should they be allowed to take part in elections, for instance? That might depend on how long they're here for. If they're here on a one-week trip and the election day falls, then we want to say, well, they should be able to vote in that. So there must be some limits on participation, but in general, we should make sure they can take part in civic life. And taking part will include being bound by the laws and thus being called to account if they violate those laws. That's important. So I find my notion of guests might, when spelled out, meet your concern. Work out what is owed to guests, what guests owe to their hosts. Secondly, life imprisonment. Well, that can mean different things. It could mean, as in America, life without prospect of parole. Whatever you do, you're going to stay in prison until you die. That seems to fall under the same objection as capital punishment. It excludes you permanently, come what may, from the policy. And that can't be justified. How about life with the prospect of parole, where you will stay in prison until you die unless you can persuade a parole board that you're safe to release? Or life imprisonment, which is imprisonment for a fixed term. Certainly in England, a life sentence, you're told, okay, you must serve at least so many years, perhaps 10 years, 12 years, and then you can apply for release to the parole board. But still, release is still going to be conditional on showing you're safe. So there is at least the prospect of being allowed back in, as it were, being reconciled, readmitted, rehabilitated, if you can persuade the parole board that you are now safe. And if it's possible for you to take the kind of step which will then persuade the parole board, and there are problems there. I'm inclined to think that in a very, very few cases where the crime is the most serious sort, we might say, especially of repeated serious crime, criminal careers, we might say in the end, look, what you've done is so serious, so destructive of the bonds of community, that actually as an Einstein, we can't see how we can readmit you after a fixed period. But here's how you can regain your standing, by showing us how you can now be trusted, i.e. you can get parole after a certain period. That seems to me to be justifiable for the most serious cases, but there are two qualifications to that. First of all, if we're going to say that, we have to make sure then that the offender does have access to what they need to do to show they're now reliable. This is a real problem, certainly again, thinking about England. If you're sentenced to an indefinite sentence and you must persuade the parole board you can be released, the way to do that is in part to show you've taken the right kind of program in prison to address your offending. You've taken the right kind of program and got through them. But too often the programs aren't available. There's a shortage of staff, they aren't available, so there's nothing you can do. That's outrageous. So if we're going to say, look, you're detained indefinitely until you can show you're safe to release, we have to make sure that we make available the ways in which you can show that, make available the programs you need in order to show that. That's one point. Second, it's also worth noting, important to note, that if we deny life imprisonment, if we say prison, the punishment is always limited, you're always going to be released in the end, that involves saying to all of us, and especially to those who might be victimized, here's the risk you must take. Here's a person who looks like they might be dangerous, they committed serious offences. To release them and say, look, we must now again trust them. And that involves collectively taking the risk that they will reoffend. But that risk, as things are now, it doesn't fall equally. It doesn't fall on all of us equally. It falls on those who are vulnerable in various ways, more than on those not vulnerable. So the insisted punishment should be limited. It's always be followed by release and readmission. Is to say we must collectively take this kind of risk. And we must collectively find support for those who are particularly endangered. thirdly, I can't read my writing now. Remind me what the third point was. Oh yes, the media. Sorry. Yeah, you're right. Of course, the media is a problem. Once the media portray you as an offender, a sex offender, then that makes life very hard indeed to gain readmission. I gather that in some countries, in Spain, the criminal record is not public. Your conviction is not reported by your name, it's just reported that the person was convicted. But the name of the offender is not published. That's a way of avoiding this kind of problem with the media. The media aren't allowed to give the name. But there are two things which matter, both of which involve the media. One is I lost my train of thought. We can't surely say in general that criminal convictions must always be kept confidential, that no one must ever know that you were convicted and served your prison term. Because some people are dangerous. And I think there are some things which people should be disqualified from if they've committed a serious offence. If I committed fraud over and over again, I shouldn't be allowed to work in financial services where I could easily commit my fraud again. If I committed serious sex offences, perhaps I shouldn't get against children, I shouldn't be allowed to be a teacher. Maybe there must be some provision for records to be available to some people some of the time under certain conditions. Well, how far should that go? Well, that doesn't yet involve the media. So should the media be allowed, here's one to put part of your question. Should the media be allowed to identify offenders when they're convicted or when they've been released from prison? In theory, of course, in ideal theory, because these are public matters. The person committed a public wrong, they've been publicly tried and punished. These should be public, we should all know. And if we could trust ourselves and our media to behave appropriately, that would be fine. We could say, yes, you've done your time, you've paid your debt, and now you're once again in good standing. And that's not how things in fact go, either amongst the public or in the media. So what would be wrong then? Here's the question, what would be wrong with forbidding the media to identify people who've been convicted? It happens now with very young offenders. There were notorious cases in Britain of murders committed by children of 11 and 12, and other less dramatic offences committed by young people below the age, I think, like 15 or 16. In those cases, the media are not allowed to report their names. They can report that there was a trial for this kind of offence and the person was convicted. They can't identify them. And they can never be identified. Why not just extend that rule to cover all offences, all offenders, whatever their age? Perhaps that would be the way forward. What do you think?
Thank you.
Thanks a lot, Professor. Thanks a lot.
I would ask for one more question, if there is anyone.
I was clearly too persuasive.
Professore, posso fare una domanda anche io?
Certo, con
La
piacere.
faccio in italiano, tanto è brevissima e magari mi dà una mano lei. Allora, la mia domanda è incentrata proprio sulla sua teoria della pena nello specifico, quindi un po' specifica, e mi domandavo perché mai la censura, che la pena è finalizzata comunque a operare nel rapporto triadico, quindi autore del reato, vittima e comunità in generale, deve essere veicolata tramite una pena detentiva. Cioè, perché deve essere veicolata tramite una pena detentiva e non può, ad esempio, essere veicolata, se la censura in sé è quello di cui stiamo parlando, attraverso semplicemente la sentenza di condanna, no? Se pensiamo alla sentenza di condanna con, diciamo, una funzione performativa, perché invece deve essere una pena detentiva a veicolare il messaggio? di censura all'autore del reato. Tutto qui.
Now, the question is, if we believe that the task of punishment is mostly censorship and communication, why do we need something additional to the sentence? For instance, why should we need prison? If we can communicate the censorship just by the decision. And so why should we have prisons if and why should we have punishment as something additional? In a sense, could not the sentence be in itself a punishment, seen as a punishment?
Yep, that's the hard question about punishment. I agree. As you say, a conviction is itself a kind of censure. Yeah, I'm told I'm guilty, I'm censured as a wrongdoer, and the judge can go on and speak more about the nature of my crime, how wrong it was, and so on. So a lot can be done just by the verdict and what the judge says afterwards. So why go on and say, and furthermore, we now impose this material burden on you? And that's not just prison. That's true of fines, of any kind of further material burden imposed by way of punishment. Why do we need that if the point is communication? The slogan answer is, well, because often mere words are not enough. And that has some force to it. Think of the reverse condition where, think of gratitude. If you've done me some great benefit, some cost to yourself, and I want to thank you. I kind of say, thank you very much, that's wonderful, and so on. But I might feel words aren't enough. I need to find a more material way to express my gratitude to you. So I buy you a present, or I do you some service. And that way, gives a more forceful, material expression of my gratitude. And that seems to make sense, seems worthwhile. Then analogously, let's say, look, in terms, when it comes to non-trivial wrongdoing, mere words are not enough, either for me to make clear to you the wrong you've done, or if I'm the wrongdoer, for me to make clear to you, I recognize and apologize for my wrong. I want to make up to you. Again, if I've wronged you seriously, I can say I'm sorry. And sometimes in some relationships, especially in close relationships, friendships or marriage, words are enough. Because words are in a context where we know each other well enough. So the words do mean something. They mean a lot. That's all that's needed, maybe. But sometimes it might seem words aren't enough, especially between relative strangers, because words are too easy. I can say, sorry, and just move on, as if it wasn't important. So to show that I recognize the importance of the wrong I did you, I take it seriously. Again, I might think I need more than mere words. I need to undertake something burdensome. Again, if it's a personal case, by doing you some service or some benefit. So then you shift to the civic realm, where the offender owes an apology, both to the victim, when there was one, but also to the wider community. I should apologize to all of you, my fellow citizens. Again, saying I'm sorry might not be enough to make clear to me that I've done wrong, or make clear to you that I recognize that. So then the sentence becomes a kind of material reparation, which conveys my apology more forcefully. And I think that does make sense. Again, I think the best example is enforced community service. I undertake so many hours of labor for the community, and that gives material force to the apology which I owe you. Again, prison is always a problematic one here, but I think when we start to see why we might need more than mere words, and the more might be some material burden which the person then undertakes. Does that help?
Yes, thank you. We don't want to take too much of your time, but I would allow myself to raise a question to you. And this is about international law, international crimes. You remember Eichmann in Jerusalem, written by Hannah Arendt. This is and also the Nuremberg trial and so on. Would your scheme, let's say model, resist, for instance, the case of, would be your model be valid for cases of crimes against humanity? For instance, now there is a discussion, you know, there is a terrible situation in Gaza and so on, and the claim has been raised, that by South Africa and not only, but that there is a genocide taking place there. And there might be, there is still a case, there is still a trial going on. So would your model, is your model applicable to so terrible crimes as, for instance, genocide?
Yes. Another difficult question. Because in the case of domestic criminal law, okay, sorry, go back. On my view as a trial, as calling to account, the accused person is called to answer the charge. So to whom are they answering? In domestic criminal law, they're answering to the polity, whose law it is. That's easy. But in especially international criminal law, well, to whom now is the defendant accused of genocide? To whom are they answering? If it's international law, it looks like they aren't answering just to the local polity. Maybe they are. Eichmann seemed to be answering to Israel, which was itself speaking on behalf of all Jews, maybe. But when you go to the International Criminal Court, in whose name is it meant to be calling a person to account? One answer given is, well, we're answering now to humanity itself. Some crimes are so serious that they concern not just the local state, but humanity itself. And we collectively, all of us as human beings, call the person to answer. And that sounds fine rhetoric, but doesn't make much political sense, because there's no such thing as a political community of humanity. So the real question, if we see trials as calling to account, then to whom is the international criminal defendant answering? There are two kinds of answer which might get us further. So when we think about crimes against humanity committed within a particular territory, within Gaza or within South Africa or wherever, we might say that the accused person should answer to the local polity, to Palestine if it exists, but since they can't call into account, then the ICC steps in and acts in their name on their behalf. We call the offender to account in the name of the victims who can't do so. The other answer is to say that we're dealing here now with the community to whom the answer is a community not of people, but of nation states. And they step in when a local nation state fails to do its job. Then the international community of nation states steps in and takes over. So I think there are ways of answering the question, but it needs to be asked, in whose name does the ICC function? And to whom is the person being called to answer? And that's a difficult question. It needs to be answered. I think there are ways of answering it.
All right. Thank you. Thank you very much. So I understand that there are no other questions. In this case, I'm very grateful to Professor Duff for his lecture paper. Thank you very much, Anthony. And it was extremely interesting and very important to us. We have several PhD students here in working on criminal law, so they have been listening you with a lot of attention. There is also a PhD thesis about your theory, Ms. 𝐀𝐟𝐟𝐞𝐥𝐿. Possibly she will contact you and in the next future.
Yeah,
and
please do. Yeah.
Yes, and we really hope, I really hope to have you with us in person.
That'd be good. Well, thanks very much. I enjoyed that. So thank you all. And I may see you in person. Yep.
Goodbye.
Okay. Bye then.
Goodbye. Bene. A presto a tutti.
Presto, professore.
professore.
Arrivederla,
Buona
professore.
giornata.
A presto, abbiamo avuto una lezione splendida.
Grazie, arrivederci.
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 A tutti, arrivederci a tutti.